I'm sorry. You want to represent yourself? The judge's tone sliced through the tense silence of the courtroom, his robe draped stiffly over his narrow shoulders as he leaned forward, peering over the rim of his glasses. His voice carried the edge of sarcasm, just enough to draw muffled chuckles from the back benches. Bruce Willis didn't flinch. He stood calmly, hands behind his back, dressed not in the tailored suit of a big-time attorney, but in a weathered grey jacket and black jeans. He looked more like a retired construction foreman than a man about to argue in federal court. "Yes, Your Honor," Bruce replied, voice steady. "I waive counsel." The judge, David Lennox, a man known more for showmanship than jurisprudence, smirked and scribbled something on the notepad in front of him. His clerk leaned in, whispering, probably asking if he remembered who this guy was. The courtroom didn't, but they would. To most, Bruce Willis was just another older man with a craggy face and a name that reminded people of some action star. They didn't know that 15 years ago, Bruce had passed the bar but never practiced publicly. That he'd buried his law degree behind 2 decades in the military and another 10 doing private arbitration for veterans who couldn't afford a voice. And now here he was, defending himself in a high-profile property dispute against Mason Development, a real estate giant known for swallowing up family land under legal technicalities. Bruce's family land, the parcel his grandfather had farmed, the one that stood in the way of Mason's $40 million suburban expansion. "Fine," Judge Lennox said with a dismissive wave. "But I hope you've read at least a few books, Mr. Willis. Mason's attorneys aren't known for kindness." Another ripple of laughter. Bruce nodded once, expression unreadable. At the plaintiff's table, Carolyn Voss, lead counsel for Mason, looked amused. She tapped her pen, eyeing Bruce like a bored lioness waiting for a weaker animal to stumble. "Your Honor," she said, "we're happy to proceed, but I would like to request a short recess to ensure Mr. Willis has properly filed his counterclaims under Rule 13A. Lennox nodded, clearly enjoying the spectacle. "Granted. 10 minutes. We reconvene at 10:20. Bruce turned, walked calmly out of the room while whispers trailed behind him like smoke. In the hallway, Bruce leaned against the cold stone wall. He didn't pace, he didn't call anyone. He simply closed his eyes, replaying every statute, every precedent, every clause tied to his case. The land had been in his family since 1932. Mason claimed a zoning loophole gave them rights to it, but Bruce had found something, a crack in their foundation. A clause buried in an easement agreement from 1971 that invalidated Mason's latest filing. He hadn't come here to perform. He'd come here to protect something sacred. Inside the courtroom, the mood was light. A few reporters chuckled to each other about the old man with a death wish. Someone joked that maybe Bruce thought real court was like Law and Order. But at 10:20 sharp, Bruce walked back in, eyes focused, and placed a single folder on the defendant's table. Judge Lennox returned and looked down. "All right, let's begin. Mr. Willis, I trust you've had time to compose yourself?" Bruce looked up at the bench, a faint smile curling the edge of his mouth. "Yes, Your Honor," he said, voice cool and sure. "And I think by the time I'm done that you'll understand exactly why I did. Want to know what happens next? Stick around, and if this chapter hit you, subscribe and drop a comment below. We're just getting started." Carolyn Voss stood, smoothing her blazer, and stepped confidently toward the bench. "Your Honor, before we begin testimony, I'd like to move to strike Mr. Willis's counterclaim entirely on procedural grounds. He's representing himself, and while I respect that choice, the fact remains, his response was filed 2 days past the deadline." Judge Lennox leaned forward, clearly pleased to have something to pounce on. "Mr. Willis, how do you respond?" Bruce didn't rise immediately. He took his time, flipping open the thin manila folder he had placed on the desk. Inside was a copy of the court's own scheduling order, with a date circled in red pen. Then he stood, calm as ever. "Your Honor, the opposing counsel is correct. The response would have been late if we were using the revised filing calendar issued on March 1st. However, my filing followed the original calendar from February 14th, which your office issued, and which was never formally superseded. According to that schedule, I am well within the deadline." He handed a copy to the clerk. Carolyn's lips tightened. Lennox raised an eyebrow, flipping through the papers. "Ms. Voss, is this accurate?" She hesitated. "I wasn't aware the February schedule hadn't been rescinded. Apparently Mr. Willis was." The judge's tone cooled slightly. "Motion to strike denied. Let's proceed." Bruce sat back down, expression blank. In that moment, a subtle shift passed through the courtroom. A few eyebrows rose, reporters scribbled faster. It was the first sign that Bruce might not be a walking disaster after all. Carolyn regrouped quickly. She called her first witness, a zoning analyst named Kent Reynolds. Young, well-dressed and confident, Kent took the stand with the ease of someone used to being believed. "Mr. Reynolds," she began, "can you confirm whether the parcel at 1643 Hillside Drive meets current zoning standards for residential development?" "Yes, it does," Kent replied. "Our team reviewed all relevant county records and—" "Objection," Bruce interrupted. "Foundation not established." The courtroom quieted. Judge Lennox blinked. "Go on, Mr. Willis." Bruce stood. "The witness just claimed his team reviewed records. I'd like to know who that includes and whether the review was performed by licensed zoning professionals, as required by statute in this district." Carolyn objected, but Lennox waved her off. "Fair question. Mr. Reynolds?" Kent shifted in his seat. I led the review. One of our interns compiled the data under my supervision." "Was that intern certified?" Bruce asked. "No." "Then your team did not meet the legal threshold for a zoning review under state law, which requires all data used in court testimony to be reviewed by credentialed personnel. I move to strike this witness's statement." Carolyn jumped in. "Your Honor, this is absurd. It was a minor procedural—" "No, Ms. Voss," Judge Lennox said, eyes now narrowing as he looked between the two. "He's right. The statute is clear." He turned to the court reporter. "Strike the testimony." Bruce nodded once and sat back down. Kent looked stunned. Carolyn pressed her lips together, flipping through her binder like it had betrayed her. This wasn't supposed to happen. A few heads in the audience turned. One man in the press row whispered, "Who is this guy?" And Bruce, unfazed, simply adjusted the cuff of his jacket. For him, this wasn't about winning theatrics. It was about building something solid, brick by brick, without apology. The real fight hadn't even begun yet. Carolyn Voss adjusted her posture, tapping her pen rhythmically against her legal pad. For the first time, her voice wavered slightly as she called her next witness, a representative from Mason Development's acquisitions team. "Mr. Ellsworth, please describe the nature of Mason's purchase agreements in the Hillside area," she said. Bruce leaned forward, attentive. This was where things would either unravel or tighten around Mason like a noose. Ellsworth, a wiry man with thinning hair and a too-tight tie, nodded earnestly. "Our firm contacted all landowners between March and May of last year. We issued notices of interest, followed by formal offers based on assessed values." "And to your knowledge," Carolyn continued, "were any of these owners coerced or misled during the negotiation process?" "No." All transactions were voluntary. Bruce stood immediately. Objection leading. "Sustained," said Judge Lennox before Carolyn could respond. Bruce approached the witness box slowly, stopping just short of Ellsworth's eyeline. "Mr. Ellsworth, how long have you worked for Mason Development?" 9 years. "And in that time have you ever been disciplined for misrepresentation or breach of ethical protocols?" Carolyn jumped up. "Objection. Irrelevant." Bruce turned toward the judge. "Respectfully, Your Honor, this goes directly to the credibility of the witness. If he's participated in coercive practices before, the court has a right to know." Lennox looked between them. "I'll allow it. Answer the question, Mr. Ellsworth." The witness stiffened. "There was a warning issued 3 years ago, a miscommunication during a contract discussion." Bruce didn't smile, didn't gloat, he simply nodded. "Let's talk about the parcel at 1643 Hillside Drive," he said, voice level. "Did Mason ever send a notice of interest to the property owner?" "Me?" Ellsworth blinked. "We sent notices to all landowners in that district." Bruce held up a letter. This is the only communication I received, an unsigned generic flyer dated June 11th. By then, according to county filings, Mason had already claimed partial acquisition rights. Can you explain how a company files interest in a parcel they haven't contacted the owner about? Carolyn objected again. Mr. Willis is testifying. Bruce handed the flyer to the clerk. I'm presenting evidence, Your Honor. Lennox reviewed the document. Ms. Voss? Carolyn looked cornered. That document appears to be a courtesy flyer. The legal notice was sent via certified mail. To what address? Bruce asked. Carolyn looked at her notes. 1643 Hillside Drive. Bruce let the silence stretch. My property hasn't had a mailbox in 5 years. It's uninhabited. That notice was never delivered. Now the tension was undeniable. Even Judge Lennox shifted uncomfortably in his seat. Bruce turned to the bench. Your Honor, I have a signed affidavit from the local postmaster confirming that no certified mail has been delivered to that address in over 4 years. If Mason failed to properly notify me, their claim to the parcel is void under state property law. He handed the affidavit forward. The judge took it, reading slowly. Carolyn's face paled. In one move, Bruce had exposed a procedural failure, one that could cost Mason not just the hillside parcel, but other acquisitions in the same zone. The courtroom buzzed. Whispers darted through the benches. Some reporters were already texting out the twist. Bruce stood silently, letting the weight of it settle. For the first time, Judge Lennox looked at him not with amusement, but something closer to caution. It wasn't just that Bruce had a case. It was becoming clear that he might actually win. Rain tapped softly against the courthouse windows as Bruce laid out a handful of aged documents before the court. They were yellowed at the edges, clipped neatly together with rusted staples. Bruce handled them with the reverence of a man holding a living thing. This, he said, lifting one sheet, is the original easement agreement between my grandfather, Harold Willis, and the Hillside Township Planning Board, dated June 1971. Judge Lennox squinted at the document as it was handed to him. It granted access to a public utility line that ran across the back 5 acres of our land. The agreement included a specific condition. No commercial development shall proceed on said land without written consent from the Willis family or its legal descendants. The judge blinked. You're saying this clause is still enforceable? Yes, Bruce replied, because it was never challenged, amended, or nullified in writing, and because under state law restrictive covenants attached to easements survive unless explicitly rescinded. Carolyn Voss looked visibly rattled now. She flipped frantically through a binder. Your Honor, we have no record of this clause in our filings. That's because Mason Development based their filings on the 1993 county database, which excludes pre-digital agreements, Bruce said. They didn't bother pulling the original paper deeds. I did. Judge Lennox sat back in his chair, thumbing through the copy. This clause, it's quite clear. Have you verified your status as a direct legal descendant? Bruce slid another document across the desk. Birth certificate and my grandfather's death certificate, listing me as next of kin. Carolyn stood. Even if this clause exists, Your Honor, we'd argue that the easement is obsolete. The utility line was decommissioned in 1996. Bruce didn't flinch. The clause doesn't mention active use. It's tied to the land, not the line. The condition survives as a land use restriction, basic property law. The judge held up a hand. Enough. I need a recess to review these documents. A beat passed. Then Lennox added more quietly, Mr. Willis, I admit I underestimated you. Bruce didn't smile. That's not uncommon. The court recessed, and Bruce walked into the hallway. His steps were heavy now, not from fear, but from the weight of everything he'd carried for months. The sleepless nights, the silence of that overgrown land, the memory of his grandfather walking those fields. He sat alone on a wooden bench, staring through the rain-streaked window. The town outside had changed. High rises now bordered where elm trees once stood, but not his land. Not yet. Back inside the courtroom, Carolyn conferred with her co-counsel in hushed urgency. The strength of their position had cracked. Bruce hadn't just defended himself, He'd uncovered a legal blind spot in their entire approach. 30 minutes later, Judge Lennox returned, face unreadable. This court acknowledges the validity of the 1971 easement clause and Mr. Willis's legal right as a descendant to enforce its conditions. Unless the plaintiff can provide written documentation nullifying the clause, I see no grounds to continue the claim over parcel 1643. The silence was loud. Carolyn stood, but didn't speak. Bruce remained still. Lennox tapped his pen. We'll reconvene tomorrow for closing arguments. But unless the plaintiff can produce something remarkable, I advise preparing for dismissal. He banged the gavel once. Bruce looked up slowly. He didn't smile. Not yet. But he was close. The next morning, the courtroom was packed. Reporters lined the back wall, laptops open. Local residents had come too. Some curious, some angry. Others simply hopeful that someone finally had stood up to Mason Development and made it hurt. Bruce Willis entered alone, as always. No entourage, no fanfare. Just a quiet man in a grey jacket, carrying the same folder that had carried him through every challenge so far. Judge Lennox took his seat and tapped the gavel. We are here to hear final arguments. Mr. Willis, as the defendant representing himself, you may proceed. Bruce stood slowly. For the first time, there was a flicker of emotion in his voice. Not nerves, but something deeper. He stepped toward the center of the room and looked directly at the judge. Your Honor, I'm not a lawyer by trade. I spent most of my life solving problems with my hands or serving people who wore uniforms like I did. But I learned the law the same way I learned everything else, by listening, paying attention, and caring. He turned, facing the gallery for a moment. This isn't just about land, it's about history, legacy. It's about people who get brushed aside because some developer thinks their silence means surrender. I didn't fight for this country just to let someone steal what my family built with their bare hands. He paused. No theatrics. Just truth. I'm asking the court to dismiss this claim not because I'm a hero or a legal expert. I'm asking because the facts, the law, and common sense all say this land doesn't belong to Mason. It never did. He nodded once, then returned to his seat. Judge Lennox blinked slowly, visibly moved despite himself. Thank you, Mr. Willis. Ms. Voss? Carolyn Voss rose, but her tone was changed, no longer combative, just composed. Your Honor, in light of yesterday's evidence, Mason Development withdraws its claim to parcel 1643 Hillside Drive. We will not pursue further action. Gasps rippled through the courtroom. Bruce said nothing. He just closed his folder. Judge Lennox raised his eyebrows, surprised but satisfied. Very well. Then I hereby dismiss the case with prejudice. Mr. Willis, your property rights remain intact. Court is adjourned. The gavel dropped. It was over. Reporters scrambled toward Bruce, shouting questions, but he moved quietly through them. Outside, the morning sun had broken through the clouds. The rain was gone, and everything smelled clean. Bruce walked the long sidewalk toward the parking lot, each step slower than the last. His truck sat waiting, the same beat-up Chevy he'd driven for years. Before he opened the door, he paused, staring out across the horizon. Far in the distance, he could almost see the top of the hill where the farmhouse used to stand. Nothing left of it now but grass and memory. But it was still his. That land, that story. It had survived. As he climbed into the truck, a man approached, one of the younger attorneys who'd watched the trial unfold. Mr. Willis? He asked. That was incredible. I had no idea you weren't practicing. Bruce smiled, just barely. I practiced enough. The man laughed softly. You ever think about going into law full-time? Bruce shook his head and turned the key in the ignition. The engine rumbled to life. No, I just needed to win once, for the right reason. And with that, Bruce pulled away, leaving behind a courtroom that would talk about him for years, and a reminder that sometimes the quietest man in the room is the one carrying the most truth. If this story moved you, don't forget to subscribe and click the video on screen. It was chosen just for you, and you're going to love what comes next.